I think that Lisa did a very good job introducing me. I'm a legal professional by training. I've been with various education and research institutions, as well as private organizations. So that's also an interesting factor to bring in when you compare some of the issues that researchers face versus maybe the more commercial organizations. In recent years, I've dealt mostly with the broad topics of privacy and data protection. And I think it goes without saying that at the VU we have our hands full complying with the GDPR because of the complex data processing that takes place in both education, scientific research, as well as the facilities and the services that the VU provides. So yeah, I just wanted to be a little bit thought-provoking here because, in supporting researchers, we often see that, data protection and privacy are one of the many things that they have to comply with, aside from things like ethical approvals and data management plans, security measures, which also tie in with privacy, but we'll get to that in a little bit. And I think that it would be interesting to see how you guys, maybe that's more for the Q&A session and for the talks afterwards, but how do we as researchers or as research support staff view GDPR compliance? Do we see it as an obstacle or an opportunity? And I will delve into that a little bit more later. I've made a short outline of the topics that I would like to discuss. Firstly, I would like to discuss those motivations. Like I said, what are some of the motivations for researchers to want to comply with the GDPR? And I think I have to give two disclaimers. It's a little bit the nature of my profession that none of this is intended to be legal advice. If you have any questions about privacy or data protection within the VU, you have the privacy champions with each faculty. If you're with the FGB, you will end up with either me or my colleague Jessica if you have questions. And all of the other faculties have privacy champions as well. If you're outside the VU or just joining in from there, then I'm guessing you have your own privacy advisors. And if there is some general topic you'd like to discuss, then my contact details are at the end of the presentation. Also, a second disclaimer is that I'll be relatively concise. Anyone who's ever dealt with the GDPR will know that it is virtually impossible to discuss all of the relevant topics, the relevant topics to researchers in a short talk like this. So that is not my ambition here. What I will say a little bit about is the motivations, a little bit about the GDPR, its background, its legislative background, the principles, and the main gateway question of when does it apply to my research, the applicability. I will also zoom in a little bit on the DPIA, the DPIA, the impact assessment that you have to do in certain situations and what it means as a researcher to have to do that for your research project. Fourthly, I'll talk about obtaining valid consent. There are many ways to look at the question of consent, and the GDPR is one lens through which you can look at the question of consent. So I will do that. And finally, and I felt a little bit obliged because I know that that's what these talks are really about. They are about open science, thankfully, and more of the ambitions that we have towards a more fair science. And I think that privacy and data protection are often viewed as maybe at odds with that. There can be tension. And I just wanted to briefly talk about how we can hopefully accomplish both, doing justice to both when looking at your research projects. So firstly, I have attempted to distinguish two types of motivations when complying with the GDPR. And if, all the psychologists in this room will probably be going crazy because this is probably not the way to dissect those motivations. As a legal professional, I have no attempt to be accurate in that. It is a little bit my observation, and I think it can be helpful to look at it like this sometimes. To see what it is we're doing and why we're doing it. So why do we like to comply with the GDPR as researchers? On the left, I have listed some reasons that could fall into the category of wanting to avoid problems. And mind you, that is a very good motivation. That is not a bad thing to want to avoid problems, because as you can see, those problems can be grave. The Swedish University of Umeå, if I'm pronouncing that correctly, was fined pretty heavily in 2020 for the reason that they stored highly sensitive data about health and sexual preference in a cloud situation where there were no sufficient security measures in place. So their data protection authority in Sweden levied a pretty large fine. And that is something that, that immediately triggers obviously some thoughts for us, because that could be us. And we will come to the fact of how IT security and privacy are related. I'm not an IT security specialist. We work together with IT security specialists, and they go hand in hand. If you want to do privacy well, you're going to need good IT security. And a lot of the measures that we implement from an IT security perspective help us demonstrate our GDPR compliance. So the list goes on. We've had the Amsterdam Hospital, OLVG, fined pretty heavily for I think it was unrestricted logging of medical records. That was the reason. And the third bullet is about the increased cyber attacks on universities. We've had the one in Maastricht. The University of Maastricht was attacked recently. We've had the Dutch Association for Scientific Research, the NVO, that was hacked. So these are real things, and they are only on the rise. Counter to that, if you're not only looking at it from the bad man's or bad woman's perspective, as we say in law, you can also look at GDPR compliance in a very different way, namely as a means to do the right thing. Now, as researchers, you are well aware of your ethical responsibilities, and of course, they vary from discipline. So even within our faculty, the FGB, we have various standards for, let's say, research that is medical in nature, or we have psychology standards within ethics. These apply. And I am of the opinion, and we'll come to that in a little bit, that you could also obviously see privacy and data protection as part of that. What I personally always find very interesting is looking at one of the definitions, the early definitions of privacy. Privacy and data protection was that it enhances it's supposed to enhance a person's control over the extent and timing of sharing oneself, whether it's physically, behaviorally, psychologically, or otherwise. And the idea is that the right to privacy refers to the individual's ability to limit the access by others to parts of their person. So that can include their thoughts, their identity, their intellectual outbringing. So there are a lot of things that you want to contain, and privacy and data protection help you do that. In research, you can obviously also think about things like body fluids, like blood, that is also a part of you as a person. Do you want to share that, yes or no? These are all kinds of questions that are at the base of when you think about privacy and data protection. And they link very much with ethics and ethical questions. That is what I wanted to start with. I believe that in the end, those two motivations, will be hybrid, and they will overlap. One time you're trying to avoid problems, and you're also trying to do the right thing. I think there's no such thing as a real demarcation. I just wanted to do that for our thought process on GDPR compliance. So the GDPR itself, I feel obliged to tell you a little bit about it. It entered into force in 2018. Of course, there was privacy and data protection before that time, hotly debated also because of the stark differences in technological development as compared to the years before. So it was also felt throughout Europe that, what we need is a uniform, harmonized regulation from Europe, and which will lead to, if you process data, let's say in Poland, and you do the same process in France, then you're compliant with the GDPR in both countries. That is still the idea. And the GDPR also does provide binding rules for all countries. But as you can imagine, European heads of state, European governments cannot always agree on everything, especially when it comes to things that sort of relate to how they're used to doing things in their countries. So what you will find is a harmonized, uniform regulation, but it contains certain open norms. And an example of that is Article 8 of the GDPR, which deals with getting consent from children for their data protection, for their data processing, I'm sorry. What that means is that Article 8 basically says you need to have rules. European countries, you need to have rules about what is the age that you will allow children to provide their own consent for their data processing. And the European rule leaves some room to member states to make their own rules. So it basically says it can be anywhere between 13 years of age and 16 years of age. Now, if we take Holland, the Netherlands as an example, we have stuck with the 16-year rule. If you want to get a child's consent, then up to 16 years old, you need to get it from the parents or the legal guardians. And as of 16 years old, the child can give it by itself. Our neighboring country, Belgium, has a different rule. They are saying, well, in the current technological shape of the world, that 16 years doesn't make sense. We have implemented the 13-year rule. As of 13 years old, children can provide their own consent for the data that's being processed about them. So there you see that in order to comply with the GDPR, which is a European rule, you will have to have different consent procedures in different countries. I should also add that if you're going to ask for children's consent in the context of research, there will be extra and additional things that you have, questions and requirements that you have to meet from ethical perspectives. So about, for instance, the way in which you get it. Should it be written forms? Should it be oral? Those have additional requirements. But I just wanted to point out to you that the GDPR, as strict as it seems and as uniform for all of Europe it may seem, it has some open norms, and you need to check. I'm, putting myself forward here, but also other privacy advisors, of course, make sure that you comply with those specific norms. If you're, for instance, engaged in research in Belgium, France, and the Netherlands, then you have to be aware that there can still be differences in legislation. Okay, so with regards to the principles, I've listed them. It's a fairly broad list, but you can see some contours as to what it is the GDPR wants us to do. And much of this comes back in more concrete requirements in the other articles of the GDPR. But we have lawfulness, fairness, and transparency. What that means mostly for researchers is that you need to have a legal ground for the data you're processing, which in most cases will be the informed consent that you obtain from research participants. Transparency is a big one. Also, in obtaining that informed consent, transparency is a very important one. So the second is the purpose limitation. You need to have specific and explicit purposes for processing. You cannot just give yourself a blank check and say, I will now take all your data and we'll decide afterwards what else we want to use it for. No, you need to specify that. Data minimization, you need to collect only what is necessary to achieve those purposes. So you can not take anything else. And also the idea is that you specify the purpose and you specify the data, and then you justify why it is that you need that data to achieve that purpose. And we'll come to that in a little bit when we talk about the data protection impact assessment. Accuracy, good data management. Accuracy, which is achieved through good data management, I should say, is something the university library helps us with greatly. Storage limitation, that is something that the GDPR doesn't give you a specific period of time for which you can, as long as you can process the data, but it says that you should keep it no longer than necessary, and that in research it's discipline specific, the question as to how long that can be. Integrity and confidentiality, basically what that comes down to is you need to have good security through tactical and organizational means, and we'll come to that also in a little bit. The big $1 million question is, does the GDPR apply to my research? And that's a question that we get often. We often find people saying, well, my data are anonymous, so the GDPR shouldn't apply to my research, right? And then we go into a discussion that often, and I should probably say that often leads to the conclusion that the GDPR does apply, for the simple fact that our definition of anonymous as humans or as people out in the world is very different from what the GDPR says that it is. So personal data are data attributable to a living natural person. You can already see some criteria there, right? It needs to be a living person. So the deceased, information about them, the GDPR doesn't apply to that, but we of course have medical laws that sometimes say something else about that. But just if you want to look at it, the GDPR does not apply to deceased individuals. It needs to be a natural person, so a person of flesh and blood, so to say. It cannot be a legal person. Information that you acquire about a certain organization, a company, the GDPR doesn't apply to that. Watch out though, if you're getting it from people within that organization, then that might still be different. Basically, it can be anything numerical, text, audio, visual, imaging, the conversation we're having right now. If you learn something about me, the fact that you're seeing me, it's all personal data. And it's also important to say that it is very difficult to sufficiently anonymize the data. So that, sometimes we'll find researchers saying, yeah, but we've anonymized the data. The threshold is pretty high. So if you think it's anonymized, but you can still identify persons on the basis of it, then that is not anonymous in the sense of the GDPR, and the GDPR still applies to your research project. So at the bottom of the sheet, I've basically put that processing of personal data is anything done with it. So anything you can think of that you're doing with data, if you're sending it to someone, whether you're archiving it somewhere, all of those processing activities, what we call it, the GDPR applies to them. Okay. So I wanted to tell you a little bit more about the DPIA, the Data Protection Impact Assessment. I wanted to start by saying in which situations is a DPIA required, because that's also sometimes a topic of confusion. Do we need to do it? It is one of those things on the list. Do we really need to do that? Well, the GDPR has some rules about it. It basically says if processing of the data is likely to result in a high risk to the privacy rights of the persons involved. Now, that is still pretty vague. We cannot really say this person is doing this type of research. Will it lead to a high risk of the privacy rights, right? So we have some additional criteria. Basically, at the FU, we also have a pre-DPIA tool, which tells you basically if you follow it, tells you you should be conducting a DPIA or you shouldn't. But there are some additional guidelines, which is, for instance, the systemic and extensive evaluation, including profiling. If you're doing any of that, which, and this is also why you see that GDPR targets not only things like research institutions, but mostly also technologically advanced companies that do things like profiling, targeted ads, that kind of stuff. So I don't think your research would easily fall into this unless you're doing something that, we haven't yet come across, but do share. The processing of sensitive data on a large scale. Now, here's often where we see that the research that is done at the FU falls into that category, because what we will see is that sensitive data, obviously things like health data and in the broad broad spectrum of health. So it's also psychological information. It's information about the state of your health. So for instance, something like we sometimes say that if you are doing measurements, they can be measurements on the body, for instance, like my heart rate, or other things. Those can be sensitive data. And if you're doing that on a large scale, well, you often do things on a large scale because you need to as a researcher, then you can easily fall into that category. The third one, systemic monitoring of public areas on a large scale. That's more for places like the city, the municipalities that do that. That doesn't often apply here. So if you find that a DPIA needs to be conducted for your research project, when should it be conducted? GDPR has something to say about that too. It should be conducted as early as possible in the research project development process. So it shouldn't be an afterthought. What we sometimes hear is that people are already planning their research. It's basically been mapped. They're saying, we'll start in September. Oh, by the way, I'll do it 2 days beforehand. I'll complete the DPIA. That's not the idea. The idea is privacy by design. The idea is that you will include that risk assessment in the further development of your study. once you've decided that you are going to conduct a DPIA, what are some of the parts that you could think about? So there are, if we look at the model DPIA, that is a document that has been distributed by the Dutch government and every other European government, and has been put into a model here at the FU. It consists of 17 parts, 4 of which I've highlighted here. And what I basically wanted to show is that aside from it being a bureaucratic requirement, you could also see it as helping you shape the way you think about the research project. So it requires that you say a little something about the data you're collecting, which types are you collecting? We talked a little bit about the special categories of data, what are sensitive data, which is often health data, and obviously things like ethnicity, genetic information, biometric information. Who are your data subjects? Are they, for instance, vulnerable people in any way, shape, or form? We sometimes consider children to be vulnerable. We consider in some instances refugees, people with difficulties in the mental area. These are all, and we see that obviously a lot of the research is conducted with and on them. So often you will find that you need to really discuss this in a very thorough nature. The 5th part that I've highlighted, also part 5, which is about the role division between the organizations that are involved in the research project. Especially in large research projects, you will find various roles. Now, if you're conducting research under the FU flag, then usually the FU is one of the controllers. They are responsible for GDPR compliance because you, as a researcher, work for them. And the FU is the responsible party. Now, but there can be more controllers. There can also be other independent controllers, or there can be joint controllers, depending on their roles in the process. Now, a controller is an organization that decides the means and the purposes of the data processing, but there can also be processors. And I think a lot of you will know the processing agreement. That is an agreement that you make between the controller and an organization that processes data on your behalf. So you give it instructions and it is not allowed to use those data for its own means. For instance, a cloud service provider can be a processor. A transcription service can be a processor. And we need to have, as the FU, we need to have contracts between ourselves and those processors to make sure that we arrange those responsibilities between us and them in terms of GDPR compliance. So then I've skipped a whole lot of parts, and if you want to learn more about that, we would be, of course, happy to help you. But part 16 and 17 are about the risks and the measures that you take. So the risks it's a pretty thorough risk assessment. You describe the risks and the impact that they have on the rights and freedoms of the data subjects. Basically, what you do is you want to ask yourself questions. You want to consider the nature, scope, and context of your project, and you want to ask questions like, what would happen if somehow we have a data breach? What would happen to the data subjects? What would that mean to them? Could it harm them physically or emotionally? Could it lead to discrimination of certain vulnerable groups? And how likely is that to happen? Those are questions that you will answer in the risk assessment part. And in the end, you will get sort of a risk map that tells you whether you are low risk, medium risk, or high risk. We usually help you guys with that in order to determine, and that's part 17, which measures you need to take to minimize the chance that those risks will come to fruition, because that's not what you want. You want to, as much as possible, mitigate those risks. And in terms of you can take those measures, and that's also, it says here on the sheet, you need to take the reasonable technical and organizational measures to address and minimize those risks. So that doesn't mean that you need the most expensive measures or the most technologically developed measures. The GDPR requires that you take those measures that fit with your situation. Now, I'm not an IT security expert, but we have those colleagues in the FU, of course, or wherever it is that you are. You usually have those colleagues, and you need to go to them to ask, hey, these are my data. This is what I'll be doing with them. Can you help me make sure that we have the right measures? And it's not only technological measures, because you also take legal measures and organizational measures. Legal measures are things like those contracts that we talked about, in which all the different responsibilities are assigned to the different parties. But you can also think about things like confidentiality agreements that you have with the staff that accesses the data. Organizational measures are things like the access control of buildings, training and awareness, instruction manuals, things like that. You document those here. Those are the things that you do to keep the risks from coming to fruition, to keep those risks from materializing. And you can also need to mention in that DPIA, and you say something like, well, I've had those risks. These are the measures I'm going to take to prevent them from taking place, but there may be some residual risk. And how are you willing to accept that? What are some of the circumstances that cause you to want to accept that? So that is what the DPIA does. It helps you structure those thoughts, because most researchers have that in their brain. This is what we're doing. It's a little bit sensitive, but we're doing this, etc. If you specify it like this, my finding is with a lot of researchers that they come to think about new things and new ways of looking at their projects. Also, especially part 5, I find interesting, because sometimes we come up with new processors in the process. All of a sudden we hear things like, hey, but aren't we also sending the data to company X? Oh, is that also a processor? Really? Should we have an agreement with them? Etc., etc. So sometimes the DPIA can uncover things that would otherwise have stayed hidden and would have impeded our GDPR compliance as the food. The thing I had here was the valid informed consent. It's basically, it aligns with the ethical requirements that we have for consent, in that it needs to be freely given, specific, informed, unambiguous. And when processing special category data, it needs to be explicit. So these are the requirements. And this was actually my last sheet. So it was about sharing data. And that is also one of the topics of today. If you're sharing it outside of the European Economic Area, which is the EU plus Iceland, Norway, or Liechtenstein, make sure that you have, and that's a legal question again, which you will probably come to us for, and you should, but it's important to know that you need to have one of these grounds, which is either the adequacy decision, which basically says that this country has adequate data protection levels comparable to the GDPR in the EU, or that you will have appropriate safeguards in place, which could be standard contractual clauses in an agreement, or that derogations apply. Now, that one is a bit too technical to discuss here. I've also listed some of the reasons you may want to share your data. Obviously, they're pretty much clear. And I've included an exercise, and I think it's a pretty obvious one, fictive examples of purpose statements. Anyone interested? I've taken these a little bit to the extreme, maybe. Do you consent to the reuse of the collected data by other professionals for other studies? Now, how do we feel about that? That is way too broad. That is way too vague. That is a blank check for you to collect anything you like and to reuse anything you like. So basically what we say about this one, this does not meet the requirement of being specific. The purpose limitation is not met. And so this type of consent we wouldn't consider valid. Second one is a bit better, right? It tells you it's more restricted. It specifies things like it needs to be another university doing a follow-up study, and it needs to be in a certain area. It is a much better, I would say, but nevertheless, your situation could be different, because maybe you already know the partners you'll be working with. And then still this would need to be narrowed down even more, or you would have to maybe name the partner. So there is no silver bullet for GDPR compliance. I do hope that through this way of thinking, we can look at it a little bit different, and maybe as a tool to also further our thinking about the research project.